Good morning, and thank you for joining me on this webinar. My name is Philip Kruger, and I'm in the legal department of RSM South Africa. This webinar is the third installment in a series of webinars that is focused on the COVID-19 pandemic. And today, we're particularly going to be focusing on directors' duties and responsibilities during these troubling times. We'll focus on the following this morning. Firstly, we'll discuss the general position. This will be a very brief overview of directors' duties and responsibilities, and we'll basically just set the tone and provide a background in terms of what the general position is. Then we'll be looking at times of crisis in particular, and particularly then we'll look at the Companies Act and what that requires. Specifically, we'll be looking then at an applied approach to Section 76. We'll be looking at trading under significantly strenuous circumstances. There we'll be looking at Section 22 of the Companies Act particularly. And we'll also be looking at what Kingfor requires. And in particular, we'll focus on the principles and practices that are applicable there. And then lastly, we'll look at good corporate governance in general and what that requires in difficult times. Jumping into the general position then. The general rule is that directors are the custodians of a company, and therefore they have particular duties. These duties are called fiduciary duties, and fiduciary duties have been codified in the Companies Act 71 of 2008. There has also been said that directors are described as the controlling mind of a company. And by this, it's purely meant that a company cannot make decisions on its own. As much as a company has a heuristic personality, a company can't act. It's not a physical being. Therefore, it can only act through its appointed organs, namely its directors. Therefore, Section 66 of the Companies Act has given directors very wide powers. If you look at the wording there, it actually says that the board has the authority to exercise all of the powers and perform any of the functions of the company. And this is really curtailed then only in two ways. It's in terms of the Companies Act itself, or in terms of the constitutive documents or the MOI of the company. In particular, if we look at the Act, Section 6511 of the Companies Act is applicable there, and it requires a number of matters to fall within the ambit of shareholder decision-making. Examples would be the amendment of the MOI of a company or entering into fundamental transactions. So too, for instance, the ratification of the actions of the company or the board of directors in excess of their authority. So those matters would typically be act matters that are required to be made by shareholders. Your MOI can then provide for additional matters called the so-called reserved matters that also fall within the ambit of shareholder decision-making. This would typically be matters that are quite important to shareholders given the particular circumstances. For instance, it may be that shareholders would want to approve capital expenditure over a certain threshold, etc., etc. Those can then be listed as reserved matters in your MOI and would be carved out and held for shareholder decision-making. Be that as it may, directors still have pretty much all of the powers that are not carved out by virtue of your Companies Act or the MOI. Therefore, with directors having these wide powers, they must exercise their powers within the ambit of their fiduciary duties. In this regard, Section 76 of the Companies Act is applicable. It's there where the fiduciary duties that was usually found in common law has been codified, but Section 76 is still informed or in a sense fueled or provided substance by the common law. In the event of a breach, there could be personal civil liability or criminal liability for the directors. If we're looking at personal civil liability, we would be looking at Section 218 of the Companies Act. And in that regard, Section 218 says that a director can be held liable for any loss or damage by any person suffered as a result of the contravention of this act. Then criminal liability would look at Section 216 of the Companies Act, And that would then purely state that a director can be imposed a fine or imprisonment or both in the event of a contravention. So your only real defense in respect of a breach would be the business judgment rule. That is also found in Section 76 of the Companies Act, and we'll be looking at the detail of the business judgment rule in one of the sections that are to follow. So moving then into times of crisis. In terms of our general position, we've seen that Section 76 regulates directors' duties in terms of the Companies Act. And it's important to note that the Companies Act does not necessarily have separate provisions dealing with external times of crisis or what is expected of directors during times of crisis. However, what the Companies Act does contain is both objective and subjective elements to testing a director's conduct in terms of Section 76. In this regard, then, the Companies Act allows for proper consideration of the particular circumstances and environment that a director found himself in when making a particular decision. So let's start off by looking at the detail of Section 76 then. Section 76 of the Companies Act requires that a director must exercise his powers, firstly, in good faith and for proper purpose. Now, proper purpose has been taken to mean that directors must act in accordance with the objective purpose for which the power was given to them, while subjectively still believing that they are acting in the best interest of the company. That also coincides then with our second element there, that directors are indeed required to act in the best interests of the company. And the best interest of the company has been taken to mean not only the entity itself, but also the collective interests of the shareholding body. And it even goes further than that, as we'll see later. As good corporate governance developed in time, it has also been taken to mean and been widened or broadened to a sense to include the best interests of the company and its stakeholders. But we'll get to that a little bit further on. The third element there is really where things get quite interesting, particularly in the circumstances that we are in now, facing the COVID-19 pandemic. It requires directors to act with a degree of care, skill, diligence that may reasonably be expected of a person carrying out the same functions in relation to the company as those carried out by that director, and having the same general knowledge, skill, and experience of that director. So two things jump out there. Firstly is the usage of the word reasonably can be expected of a person. So it brings in this degree of a reasonable director. Now that typically in legal terms would be an objective test. Objectively, there's this reasonable director and he acts in a certain way. However, there's also a subjective element to paragraph 3 there. And that is that reasonable director must have the same general knowledge, skill, and experience of the particular director in question. So I'm going to stand still here for a second and just delve into this a little bit, because you may well say to me, well, this is Section 76. We've been on a number of courses. What does this mean in light of the COVID-19 pandemic? And really what it means is your first two elements remain steadfast. Directors, it doesn't matter in which circumstances a director finds himself in. A director would still be faced with the duty of acting in what they honestly believe to be, excuse me, the best interests of the company, its shareholders and its stakeholders. And they must then act within the ambit and the objective purpose for which they have been given their powers. And that remains at this point in time the operation of a profitable and sustainable business. Excuse me. This, however, starts to get quite interesting when we get to point 3, because that's where we take into account the circumstances that the director faces. So in terms of the objective and subjective nature of that point 3 requires, we have to ask the following question. Excuse me again. What would a reasonable director have done carrying out the same function of director, having had the same knowledge, skill, and experience and being in his or her shoes whilst facing this COVID-19 pandemic? This question then brings into play the reasonable director and requires the application of the classic test in the Kruger versus Coetzee case. Now, the Kruger versus Coetzee case is a case that's very well known in delictual law, and it basically sets the test for negligence. So we'll look at this test for negligence by virtue of Kruger versus Coetzee, but we have to look at it through a Section 76 lens. In other words, excuse me, what would a reasonable director in the same position with the same knowledge, skill, and experience have done, and would they have foreseen that there is a reasonable possibility that his or her conduct is causing loss or injury during these circumstances? Secondly, if that question is answered by a yes, you have to ask whether such a reasonable director would have taken steps to guard against this. Excuse me. If that answer is indeed yes, the final question needs to be, did the director in question fail to take these steps? So as you can see, there's quite a lot there that places this reasonable director within the shoes of the director in question. So in other words, we're not comparing ourselves to a perfect director. We're comparing ourselves to a reasonable director who has the same general knowledge, skill, and experience as the particular director. And this is purely because mistakes happen. And it's here where the business judgment rule comes in. Things go wrong. And if things go wrong, particularly in circumstances where we're dealing with a sudden emergency, the question that you need to ask is, can you defend your actions? If you can defend your actions, chances are that you have a reasonable probability of being able to use the business judgment rule. You need to ask yourself the following questions. Did you take reasonably diligent steps to be informed about the matter? And if so, did you have a rational basis for believing that you were acting in the best interests of the company and its stakeholders? And did you indeed believe that it is in the best interests of the company and its stakeholders? If you can answer that affirmatively, and provided you can provide evidence to that fact, in other words, were these decisions minuted properly? Do you have proper supporting reports and evidence supporting your rational decision? Can you provide objective proof to the fact that you applied your mind? If all of those matters are in place, chances are very good that you could employ the business judgment rule as a remedy against a claim for a breach of Section 76. Moving on then to our second portion, which would be looking at trading in these troubling times. Now, in this regard, we have to look at the provisions of Section 22 of the Companies Act. Section 22 at face value, if you look at subsection 1, is quite simple. It requires that a company must not carry on its business recklessly, with gross negligence, and it must not have the intention to defraud or act fraudulently. Now, most companies trading on an above-board basis would easily be able to satisfy that test. However, if you then look at subsection 2, it goes on to state that if SIPC has reasonable grounds to believe that a company is either trading on the basis set out in subsection 1, or, and this is where it becomes particularly relevant now, a company is unable to pay its debts as they become due and payable in the normal course of business. SIPC may then issue a series of notices which ultimately may require a company to cease trading. So in other words, SIPC will issue a notice requesting the company to show good cause as to why it should be permitted to continue trading. If that company then fails to do so within 20 business days, SIPC may issue a notice prohibiting that company from trading any further. And it's really here where we need to be honest with ourselves. We know that we are not trading under normal circumstances. Most companies are finding themselves in uncharted territory facing the COVID-19 pandemic, particularly in respect of productivity and lower levels of profitability. The ultimate reality check there definitely would have been during last week, where we saw Edcon and SA Express, two absolute giants who are really in the final stages of their battle for survival. And really, all of us, or most of us, are facing similar concerns. We're all worried about paying staff. We know that the UIF provides some relief, but in truth, it's very, very limited relief. We're all concerned about rental payments. Some have been able to successfully negotiate delays in rental payments, etc., but not all have been able to be successful at that. Mortgage payments, contractual obligations, the invoking of force majeure clauses is another critical issue. Potential claims, servicing debt obligations, very limited operational capacity, particularly with the working from home scenario. Major transactions on indefinite hiatus, particularly as globally the COVID-19 pandemic has really stunted the activities of companies. And then obviously serious liquidity issues. And it's due to these serious concerns that SIPSI has entered the fold. And they have issued practice note number 1 of 2020, which was issued on 24 March 2020. And it literally says there, in light of the COVID-19 pandemic and in terms of the Disaster Management Act 57 of 2002, SIPSI undertakes not to invoke its powers under Section 22 of the Companies Act if a company is temporarily insolvent and still carrying on business or trading. But there's an important qualification. It says, provided that the insolvency is due to the business conditions caused by the COVID-19 pandemic. So the first thing that's important to note there is if a company was already trading recklessly, or if that company cannot attribute their financial woes to the COVID-19 pandemic, that company will not fall within this exception that SIPSI is making by undertaking not to invoke its powers under Section 22. Secondly, what's important to note about the notice is that the undertaking by SIPSI will lapse within 60 business days after the declaration of the national disaster has been lifted. So in other words, it provides you with some time of recovery, but not a lot of time. So with that relief having been granted, let's move into our next part of this, which focuses then on times of crisis and the Kingfor report. Now, previously we have discussed Section 76 and the business judgment rule and how we would be applying this within the COVID-19 pandemic scenario. However, in order to discharge those duties as per Section 76, or in order to invoke the business judgment rule, you cannot view that section in complete isolation. Therefore, we must have regard for Kingfor. Now, quite often when you consult with companies, particularly companies within the private sphere, they will ask the question, why is Kingfor important? There is this perception that Kingfor applies in the listed and public space and not really to private companies. That firstly is a misnomer. Kingfor states that it applies not only to all companies, but to all organizations. So in other words, also applies to trusts, CCs, etc. But secondly, to some extent, there might be merit in asking why is Kingfor important, because we know that Kingfor itself states that it's voluntary principles and leading practices. In other words, Kingfor itself is not law. But, and that's a very important but, firstly, it would not be possible, or most likely it would not be possible, to invoke the business judgment rule without being able to evidence as a director that the board has acted within the requirements of Kingfor. And the reason for that is largely found within our second point there. And that is that courts have generally referred to Kingfor in determining whether boards have fulfilled their fiduciary duties. So in other words, when there has been a dispute going to court, or if courts were called upon to make a declaratory order, they have generally gone back to look at what Kingfor says the board should be doing in order to determine whether the board has made itself guilty of a breach of their fiduciary duties. And in that way, Kingfor in fact becomes law. So Kingfor is quite important to take cognizance of in this scenario. So now, knowing that Kingfor is quite important, what obligations would Kingfor place on directors in light of the COVID-19 pandemic? So firstly, we'd be looking there at Principle 3 of Kingfor, which states that the board should ensure that the organization is and is seen to be a responsible corporate citizen. Now that places an immediate obligation on the directors of a company in light of the COVID-19 pandemic. To be seen as a responsible corporate citizen, you cannot ignore the fact that government has issued certain regulations, that we have to create safe working environments, etc., etc. So how should a board go about achieving this? And for this, we can look towards guidance in terms of Practice 14 of Kingfor, which states that the board should oversee and monitor on an ongoing basis how the consequences of the organization's activities and outputs affects its status as a responsible corporate citizen. And Kingfor then provides further guidance as to how this oversight and monitoring should be done. So in doing this, you should measure the performance against the targets agreed with management in the following areas. So firstly, you should look at your workplace. Secondly, the economy. Thirdly, the society. And fourthly, the environment. Going back to workplace then, Kingfor gives specific subsets, and it says there you should specifically be focusing on employment equity, fair remuneration, and then very importantly, safety and health of your employees. If we're looking at the safety and health of your employees, we can't ignore the fact that there's an obligation to empower employees to work from home during this period. Measures should be put in place to look after the health of affected employees, particularly if we are looking at essential services companies. The economy, I think, speaks for itself. We all know that the economy has taken quite a large hit during this COVID-19 pandemic and will continue to do so. Society particularly lists public health and safety as an element and a subset that should be taken into account and should be seriously considered by the board. And we cannot ignore public health in the fact that we must adhere to the measures and follow the practices to ensure that the organization is not seen to be increasing the risk of the COVID-19 pandemic spreading. And then lastly, the environment. Again, speaks for itself, but the should be taking into account what their output's effect would be on the environment, particularly in this time. Looking then at what must be considered in addressing Principle 3 and Practice 14 in the current circumstances. So firstly, we have to look at Section 8.1 of the Occupational Health and Safety Act, the abbreviation there being the OSH Act or OSHA, which states that every employer is obliged to provide and maintain, as far as reasonably practicable, a working environment that is safe and without risk to the health of its employees. That is then the primary responsibility of the Chief Executive Officer or any person deemed to be the Chief Executive Officer of an organization. Now, this has obvious implications in the current circumstances. Work from home obviously needs to be in place. There's a clear obligation that the organization must manage the risk of contamination in the workplace. This is particularly difficult if you are within the essential services provider space. And then lastly, you have to find a way to keep your employees informed as to the latest developments within the COVID-19 pandemic. Then secondly, also looking at the National Environmental Management Act. And there, this act states, or NEMA as it's called, states that directors may be held liable for environmental offenses. Obviously, liability in terms of NEMA and the OSH Act would be founded within statutory compliance. and it comprises fines and possible imprisonment. And what is very important to note is that the Companies Act places very specific limitations on when a company may indemnify a director. So there we are specifically looking at Section 78 of the Companies Act, which states that a company cannot relieve a director of a breach of fiduciary duty, misconduct, or willful breach of trust. Also, a company may not pay a fine imposed on a director as a consequence of having been convicted of an offence, excluding strict liability offences. So, if a director participated in a decision or activity that caused an offence, either in terms of the OSH Act or NEMA, and they can be seen to have breached their statutory duty to act in good faith with care, skill, and diligence, and in the best interests of the company, they will effectively have no recourse because they would not be able to invoke the business judgment rule, and they would not be entitled to be indemnified by the company or the insurance that the company has taken out. So now knowing what Kingfor requires and what the potential risks there are, let's look at the general requirements that good corporate governance would have in these troubling times. And there I want to start off with a quote from Rosa Parks, the very well-known civil rights activist. And what she said was, "You must never be fearful about what you are doing when it is right. I have learned over the years that when one's mind is made up, this diminishes fear. Knowing what must be done does away with fear." And that, to me, that last sentence is really what the emphasis must be placed on when we are considering the actions of the board and good corporate governance in these times. Knowing what must be done does away with fear. So in order to do that, the board must know what to expect. So firstly, it has been stated that in any corporate emergency, boards would have to face the following effects, and they must expect that there would firstly be an increase in the tempo of decision making. Now we saw that happening when the lockdown was imposed. The address of the president came, and really very fast action had to be taken to empower employees and to enable employees to work from home. Then secondly, there's an increase in the severity of external consequences, such as markets, and we've seen that on the JSE. We've seen that with the currency fluctuations that has recently occurred. Thirdly, there'll be an increase in the complexity in environment, and here obviously we can reference employees having to work from home. It certainly has created challenges, certainly has increased complexities, and certainly has challenged organizations in having to work in a different way than they may have been working before. And then lastly, boards have to accept that there will be an atmosphere of uncertainty. Now, with the presence of these elements and these things that we need to consider, it is with the utmost importance that the board must implement a well-considered crisis management plan. Now, a good crisis management plan in terms of good corporate governance would set out the board's obligations in terms of communication. That would be communication to stakeholders, shareholders, suppliers, may even be departments of government. It would set out the operational essentials of the organization. It would set out staffing strategies, as well as remote working plans and other contingencies. However, not all emergencies can be foreseen. And particularly then, not the severity and the impact of emergencies cannot always be foreseen. So where such a plan was lacking, or even in some instances non-existent, I would suggest that a board would be expected to act reasonably within the ambit of their fiduciary duties, and above all else be guided by fairness to all of its stakeholders. So again, in this regard, to me, this is a fundamental element of good corporate governance. Now, it's important to note here, and we touched on that earlier, that the role of companies have evolved from a responsibility to shareholders only to being a responsibility to a broader category of people, being stakeholders, which would include shareholders, employees, the society at large, the environment, suppliers, creditors, debtors, the government, etc., etc. Now, how must the company go about achieving fairness in its dealings with these stakeholders during the COVID-19 pandemic? Well, as we have mentioned there earlier, first very important thing would be providing a safe working environment, particularly if you are in the essential services space. And there we have to mention again the implications of NEMA and the OSH Act. Secondly, providing fair labor practices, particularly thinking about possible retrenchments and possible temporary retrenchments, etc., etc. Providing for the well-being of employees, and that includes physical, mental, and financial well-being. And then, very important during this time, responsible application of force majeure clauses in respect of suppliers, contractors, and the like. It's very important to note there that force majeure clauses are really only to be implemented if there has been a true supervening impossibility. Therefore, it should only be invoked if it is impossible to perform and not merely difficult or possibly delayed. Also, ensuring that employees are in a position to adhere to government regulations, particularly now during the lockdown period. Employing commercial practices that provides for a sustainable business and that can provide shareholders with long-term benefits. And here we are, in truth, looking post the COVID-19 pandemic. What happens after this? And ensuring that the company abides by the requirements of government during the declaration of a state of disaster. So in other words, practically adhering in respect to which entities are seen as essential services and which entities are not. We are quickly running out of time, so I am going to conclude here. And in conclusion, what we can say is that in these trying times, future generations will be looking back at this as either a shining example of how companies and corporate entities were to be resilient in the face of great danger and great crisis, or they would take an example of what not to do. And good corporate governance will require that we have to strive for the former and avoid the latter. With that, I'll conclude, and I would like to just thank you for your time. I would also want to mention that our next webinar in this series will be exceptional tax measures in respect of COVID-19. Thank you again, and please stay healthy and safe out there.